Today we're going to talk about Civics 6, about the importance of law, the rule of law, the Bill of Rights, the consequences for lawbreaking, and juvenile justice. Why is the law important? Why does it matter? Law is a written expression of the social contract. Hammurabi was one of the early givers of written law. He was a king in ancient Babylon. He ruled from 1792 to 1750 BC. Hammurabi's code, his law code, was written, and it included penalties. The penalties may be seen as harsh by our standards. They were literally an eye for an eye, but by the standards that came before Hammurabi, they're quite reasonable. Hammurabi's law may be understood as no more than an eye for an eye. If someone gets in a fight and they take someone else's eye, then their eye may be gouged out, but only one eye, not both eyes. So it limits penalties for lawbreaking to those that are similar to what the lawbreaker has done. Interestingly, Hammurabi's code assumes the innocence of the accused. Like American law, one must be proven guilty to be punished of a crime. The law is written on stone stela. This was diorite, very tough black stone. And these stone monuments were put in cities, towns, throughout the kingdom of Babylon. And it had a written law code, and it began with a purpose. Our Constitution begins with a purpose. We, the people, in order to form a more perfect union, establish justice and ensure domestic tranquility, and so forth. Well, the purpose of the Hammurabi law code was to prevent the strong from oppressing the weak and to see that justice is done to widows and orphans. Widows and orphans being the most vulnerable in their society. So the idea of the law is to protect the weak from the strong. That's very much like what Hobbes would have called for in law. Hobbes was saying the state of nature, the strong naturally oppress the weak. The purpose of law, the purpose in giving up a little bit of our freedom within the social contract, is that we obtain safety from the stronger. When we are weaker, or when our family members are weaker, that they will be protected by law when we perhaps cannot protect them ourselves. That's the trade-off in the social contract that Hobbes finds desirable. The rule of law means that law is applied fairly and consistently. And it doesn't matter who you are, justice is blind. If you ever seen a picture of Lady Justice holding the scales and the sword, she's blindfolded. That means she doesn't favor one person over another. She's neutral. She's fair. The opposite would be the rule of men. The rule of men was best expressed by Louis XIV, the Sun King of France. And Louis XIV said, "L'état, c'est moi." I am the state. I am the government. Louis's word was absolute. If Louis said, "Off with your head," off came your head. No court, no appeal. His word was the law. Unlike even the kings of England by that point in history, the kings of England were limited. There was an English Bill of Rights. There was a Constitution emerging in England. There was the Magna Carta in England. So even the king was under the law. Even the king couldn't simply say, "Off with your head," and your head came off. Well, most of the time the king couldn't do that. The Bill of Rights includes amendments. There are 10 of these. The first deals with religion. It states there will be no establishment of a government religion in the United States. No church of the United States paid for by the taxpayers regardless of their beliefs, as have been in England with the Church of England. It also includes a prohibition that Congress may not establish any law, create any law that limits the freedom of religion, that says this religion shall be banned, we will suppress this religion, we will take away their buildings, we will arrest their leaders. There are countries even today where religions are suppressed by the government. Not so in America. Now, does that mean you can make up a religion and do anything you want to? Well, no, it doesn't. For example, one could be free to preach they believe in human sacrifice. However, conducting a human sacrifice would still be considered murder. So, there is no prohibition on having a religion, but religions can't just do anything they want to under the law. There are reasonable limits. The freedom of speech. The freedom of speech is intended particularly for unpopular speech, the speech no one wants to hear. Popular speech doesn't need protection. Free speech is mainly oriented toward political speech, that is, making a speech for or against a candidate, for or against a cause, and being protected. However, it has been expanded over the years to protect more and more forms of expression, movies, radio, not just the speech on the corner. There are limits to the freedom of speech. Defamation, slander would be one. To falsely harm someone's reputation is slander. One may be sued for slander. Putting it in print would be libel, but same principle. One cannot shout fire in a crowded theater and create a riot. One may not call for others to break the law or conspire to break the law with others. So there are limits on free speech. But generally, political speech in a public forum is absolutely protected by the U.S. Constitution, by the Bill of Rights, by the First Amendment. Freedom of the press. In the 1700s, the press was the internet of that day, the newspaper, the Facebook, or Twitter of those times. Today, the freedom of the press is understood to include all those, plus modern forms of expression, of speech, television, film, and so forth. So there is protection for freedom of expression, regardless of its form. Again, there are limits. Calling for the overthrow of the United States government would be one of those limits. Calling for a new election or a new party to be elected would be fine. Calling for a violent overthrow for riots in the street, that would not be permitted speech. The freedom of assembly, particularly peaceable assembly, to get together, to protest, to bring people together to meet and exchange ideas or express ideas, that's protected by the First Amendment. To riot, to burn, to tear down, to destroy, to commit crimes, that is not permitted. So peaceable assembly is permitted, rioting is not. The Second Amendment deals with the militia and personal firearms. It states that the states may have militias. Today we call those the National Guard, and Alabama has one. But it also says that arms, and by that it means firearms, guns, for personal use, may be carried and owned by citizens. That citizens have a private right to keep and bear the means of self-defense. This is seen as a natural right. In nature, most things can defend themselves in some way. Even a rabbit can bite back at a dog or a fox attacking it. So people are allowed to, under the natural law theory, the natural rights theory, to defend themselves, to have firearms. Does that mean a person can legally own any weapon with no restriction? No. Does it mean they can carry a concealed firearm anywhere they want to? No, it doesn't. But under current law in Alabama, one may apply for a concealed weapons permit, and unless there is a good cause, like a past criminal conviction or mental illness, the sheriff shall issue the concealed carry permit. Some Guns that are more extreme, for example, full machine guns, may require a special federal permit to own. But even a cannon and even a machine gun can be owned by a private citizen in the United States with the right permits. The Third Amendment deals with quartering. That's not something we think about a lot today, but the people of Boston certainly did. When young soldiers showed up in their homes demanding to be fed, housed, and have their laundry done, and the British would arrest the homeowner if they refused. Who would want some young strange soldier sleeping in the same house with their young daughter? And yet that was the law, the punishment for the people of Boston when the British were angry with them over the Tea Party and over their resistance to British rule. Well, we put in our Constitution no quartering of troops. That is, the government cannot force you to house troops in your private home. There is an exception: wartime. During war, Congress can write laws that require private citizens to house soldiers. However, this isn't something we do in most wars in America. Certainly not in our current wars, nor in World War II did we have quartering. The Fourth Amendment deals with the rights of the citizens to privacy. That is, to no unreasonable search and seizure. The government cannot search persons, their papers, or their things unless a judge has issued a warrant. The warrant has to state that there is probable cause and has to explain why law enforcement, for example a sheriff or a police officer, believes that someone has done something wrong, and it must specifically state what's being looked for. It can't just be a general warrant. It can't just be issued for anyone passing by this particular place. There must be a cause for a search. So what about getting on airplanes? Why do you have to take off your shoes? Well, you don't have a constitutional right to get on an airplane and fly. And the airlines and the government can impose some searches on you getting onto an airplane for security reasons. And if you don't like that system, you don't have to fly. You could drive or take some other means of transportation. The Fifth Amendment deals with the accused, along with the Sixth, those accused of crimes. The alleged criminal, the accused, has rights. Those rights under the Fifth Amendment include the right to be indicted by a grand jury. That is, a prosecutor has to sell a larger jury, not the petty jury of 12, but a larger one, perhaps 24, sell that larger jury on the idea that there is enough evidence to hold a trial. The prosecutor has to prove in a major crime that it's even worth bringing the evidence to court. And if a prosecutor, who is the only one allowed to speak to the grand jury, the defense attorney is not allowed to speak to the grand jury, if the prosecutor can't persuade a large group of people that he has enough evidence for a trial, there probably isn't really a lot of point in going to the expense of trying someone before a petty jury. So this is a way that gives the citizens a right to decide who goes on trial and who does not. If a trial occurs, the government only gets one shot. That's called double jeopardy. If no trial occurs, it means the grand jury sent back a term of no bill. No bill means no indictment. There's not enough evidence to bother with the trial. The prosecutor is wasting his or her time. Now let's get to double jeopardy. Double jeopardy means that you cannot be tried twice for the same crime. For example, someone's tried for murder. They're acquitted. The jury does not find enough evidence. They're let go. A year later, the government finds additional evidence to say that they committed the murder. The government can't bring them back to trial. They cannot try them twice for the same crime. Now, you can be tried twice for the same event, as follows. Timothy McVeigh blew up the Oklahoma City Federal Building in 1995. He was tried by both Oklahoma and the federal government, or at least could have been. The federal government convicted him, and he got the death penalty in federal prison. But the state could also try him for murder while the government's trying him for terrorism. because those are different crimes happening under different levels of jurisdiction. The federal government trying him for attacking a federal building and for using explosives, and the state trying him for the crime of murder on their soil. So you could be tried by both federal and state governments for the same event, but for different crimes coming out of that event. That is, that you violated the law of one level and another level at the same time. That is not considered double jeopardy, because in violating the laws of each, you committed separate crimes even during the same act. Self-incrimination. You cannot be forced to testify against yourself in court, in criminal court, that is. Now, in a lawsuit, in a divorce proceeding, yes, you may be required to testify even when it's not in your interest to do so, and you must speak truthfully, or you may be convicted of perjury, that is, lying under oath in court, which is a crime unto itself. Due process, and about lying anytime you're under oath, not just in court, I should say. Due process rights refer to the right to have your side of the story told, to have some sort of legal process with impartiality before the government can take your life, that is, execute you, take away your liberty by locking you away in prison or putting you on probation or parole, or taking away your property, that is, taking away your things, fining you, confiscating your goods. Now, there's another process about the property that gets used sometimes where the government actually sues the property, but we're not going to really get into that today. Understand there are some exceptions and a couple of loopholes the government can use when it comes to taking away property. Some of those loopholes are being closed, and there's been a lot of criticism of that in the last few years. Eminent domain refers to property being taken away by the government. Let's say you own a farm and the government wants to build a highway through one of your fields. The government can force you to sell that field to them. Even though you might not want to sell it at any price, the government can force you to sell, and then they must pay you a fair price for the property that they've taken. You do get due process rights in this. You can take the government to court. Most of the time citizens lose. Occasionally, however, they do win in eminent domain cases. Most people just take the money and go on because they're afraid that the cost of fighting the government will be greater than the value of what's at stake. The Sixth Amendment continues with the rights of the accused. The accused have a right to a trial by jury, and that trial must be speedy. If we didn't have the right to a speedy trial, the government could simply arrest someone and hold them awaiting trial for the rest of their life. Simply give them a life sentence in prison by never actually bringing the trial. So we have the right to a speedy trial. And if the prosecution doesn't bring the trial in time, the defense attorney may ask the court to simply dismiss the charges on the basis that their client is being denied a speedy trial. What does speedy mean? Unfortunately, in some cases, speedy might mean a year or two in jail awaiting trial in some places. That does happen sometimes. It's of questionable constitutional merit. A jury trial is also another right of the accused to be tried and have your fate decided by your peers, not just a professional judge. The jury is to be impartial. That is, it should be people who don't know you, don't know the prosecutor, don't know the alleged victims, don't know anyone involved. That they are neutral, they are impartial. And it should be local, to where the crime is alleged to have been committed. So if you're accused of committing a crime in Dothan, you are to be tried in Houston County, in the local area. Your lawyer may request that you not be tried in the local area. Your lawyer might go to court and say, Your Honor, the judge, everyone in this community thinks my client is guilty. The newspapers, the internet, the media have biased everyone in the area against them. I would like the trial moved so they can get an impartial jury. And a judge may choose to grant that request. Witnesses may be compelled to appear in court. You can require that someone show up and testify in your case. If they do not show up, they may be found in contempt by a judge and arrested for not coming to court and literally dragged into court. So you have the right to compel others to testify on your behalf. You also have the right to counsel if you're accused of a crime. By counsel, we mean lawyer. The prosecutor is going to be a professional attorney. It's only fair that those accused of crimes who can't afford an attorney of their own be provided with an attorney to make the playing ground level. Because attorneys are very aware, of course, of the law. They spent 3 years in law school, plus a career in law. An ordinary person who hasn't gone to law school doesn't really know enough to defend themselves well in court. Yes, there are cases where people have defended themselves in court and been acquitted, but they're at a distinct disadvantage in those cases. So the Constitution requires that those accused of a crime be provided with a lawyer. If you're sued, are you provided with a lawyer? No, you're not. In a divorce case? No. Those are civil cases. We're talking about criminal cases. In a serious felony, a criminal case, you're going to be entitled to counsel to a lawyer. Speeding tickets? Probably not. The Seventh Amendment deals with lawsuits. They have to be heard by a jury, by your peers, if they're over $20. Of course, when this was written in the late 1700s, $20 was a lot of money. Today, not nearly as much value, but the Constitution says 20. It would have to be amended to change that. So you have a right to have your lawsuit heard by a jury. Sometimes people waive that right and just let a judge decide. The Eighth Amendment says no excessive bail or fines. So what is bail? Excuse me. Well, bail is money that you have to put up in order to be released from jail awaiting your trial. If you can't post bail or bail is denied, you have to stay in jail until your trial. If you're convicted at your trial, then you may be sent to prison. What's the difference? Jail is where you're held while you're awaiting trial, while the system figures out what to do with you. Prison is where you go once you've been found guilty and you're to be punished. So that's the difference between jail and prison. Bail is something you pay to get out of jail awaiting your trial. If you show up for your trial, then the bail money goes back to you or whoever posted it, perhaps a family member. If you skip bail, that is, you don't show up for your trial, then a warrant's put out for your arrest and the court can keep the money you put up as bail. Fines are money charged for committing crimes, part of the punishment. They may not be excessive either. The idea is that for a minor offense like speeding 5 miles per hour over the speed limit, the fine shouldn't be something that would break someone, but it should be enough to deter them from driving too fast. Cruel and unusual punishment. The Eighth Amendment prohibits punishments that are cruel or unusual. For example, whipping someone, taking them out and beating them publicly. That was a common punishment in the colonial period under British rule. That's not a punishment that we use in the United States today. We don't pillory people anymore. We don't put them in the stocks and throw rotten vegetables or rocks at them. That would be cruel and unusual. Punishment should be consistent, fines, jail time, community service, and not exotic in nature. When you hear about a judge sentencing someone to stand outside the store that they shoplifted from and hold up a sign saying, "I am a shoplifter," to shame them, that's something the person chose over going to jail. If the person had refused, the judge would have simply sent them to jail. So those kind of public shaming punishments are generally an agreement between the judge and the accused or the convicted in order to avoid the actual jail time. They suffer some sort of embarrassment. The Ninth Amendment deals with other rights. James Madison, who was instrumental in bringing the Bill of Rights into law, was concerned that if we listed out the rights that we had as Americans, then in the future people might misunderstand that and believe that those are the only rights that we have. Well, we do have other rights. There's no way to list every right we could have under natural law that nature may have given us. So Madison put in the 9th and 10th Amendment just to make it clear that people have the right to do things not listed in the Bill of Rights, not included in the Constitution. And the 10th Amendment includes the states in that. The rights of the people in the states that weren't listed in the Constitution or Bill of Rights are still the rights of the people and of the states. So the 10th Amendment is used by those who want the states to have more power to justify states' rights, because states do have some rights against the federal government. The states had far more rights against the federal government before the Civil War. After the Civil War, as federalism progressed, the states lost power and the federal government gained power over time. The consequences for committing crimes can be severe, and they include the following. Fines. You may be fined for a crime that you've committed, forced to give up money. Time is money, it may be said. Therefore, when you're fined, the time you spent earning that money is taken away from you, and you can never get that time back. Our lives are limited. The days, hours, and minutes that we live are finite. Therefore, to take away our money, our earnings, is to take away a bit of our lives to repay the wrong that we've done. Imprisonment also takes away time, but in a more literal sense. One is locked away from society, from one's friends, from family, and not allowed to pursue one's vocation, one's work. And it limits one's liberty. Of course, another goal in imprisonment is to keep someone away from the public so they can do more and more harm to people. Some people are dangerous and need to be locked away from others. Of course, within imprisonment, there's also the possibility of the death penalty, of someone being executed for a crime. That is relatively rare and only imposed in cases of murder with some additional factor. But imprisonment is far more common, and the United States puts more people in prison than most other countries do. Community service. Community service is a way for people to repay society for the wrongs that they have done, and it might include labor, for example, picking up trash beside the road, to repay society, the community, for something they've done. That's usually used with more minor crimes, not usually so much with violent crimes. Violent crimes tend to draw prison sentences or, in the most extreme cases, the death penalty. Restorative justice is intended to rehabilitate the offender. That is, to help someone to overcome their criminal tendencies and to again become a good person. It's also intended to reconcile that person with their community, to help them again be a part of the community they're from, to hold down a job, to function as part of that community, to be forgiven in a sense, and to rejoin their peers on a more equal footing. So restorative justice has the goal of bringing the offender back into community with those he's offended against, or she is offended against. Juvenile justice is the justice system for young people, those under 18, those not fully adults, maybe not fully understanding the consequences of their action. Juvenile justice is less severe than adult justice. A juvenile would be put away for less time for doing the same thing an adult has done, unless, of course, they're tried as an adult. We'll talk more about that in a minute. One consequence for juveniles is alternative school. If a student does something bad in the school, they may be sent to alternative school. When I taught in alternative school, I saw people there for fighting sometimes, and they may be given classes that are small. I often only had 3 or 4 students in a class period when I taught in an alternative school, and I could give them a lot of individual attention and help them to learn. There were actually some students who went to alternative school and chose to stay there because they realized that the small class size worked better for them. Boot camp is a little more extreme than alternative school. Again, when I taught in alternative school, if someone messed up in the alternative school, they were sent out to boot camp. Boot camp involves military-style discipline, wearing combat boots and fatigues, marching around in drill, sitting silently at one's desk doing work that was sent down by a classroom teacher. That's what boot camp can be like. Boot camp is intended to instill discipline in a youthful offender to help them have a more orderly life and to grow up not to be a criminal. Confinement may be used with youth. There are special confinement centers, juvenile halls they're sometimes called, where youthful offenders may be sent. That's for the sake of community safety. Even at a relatively young age, some young people may be too dangerous to be allowed out in society. And they are confined, sometimes till they're 21, in a juvenile justice facility. It's also intended to deter youthful offenders. Even young people may face serious consequences for violating the law. And the law establishment hopes that these consequences deter some from going that route. For the most serious youthful offenders, the phrase tried as an adult comes into play. Even a young person who commits murder, armed robbery, or a very serious, often violent offense may be tried as an adult in those severe cases. If they are tried as an adult, they are sentenced as an adult. They are sent to adult prison with adult offenders. It's a scary place to be. It's not somewhere anyone in this room would want to be. Make sure that you follow the law, that you stay out of trouble. So today, we've talked about the law as part of Civics 6. We talked about the importance of the law, why law matters. We talked about the rule of law versus the rule of men and why the rule of law is more fair and more consistent and better. We went through the Bill of Rights and discussed the rights given us by the Bill of Rights. We talked about the consequences for violating the law. And we talked about juvenile justice. There is one more point I want to touch on. Our standard talks about the Bill of Rights, but the Constitution itself gives us some rights. For example, the right of habeas corpus, that is that if we are arrested, we, the body, corpus, not the dead body, the living body in this case, must be taken before a judge, and the community must know who's been arrested, who is in jail. Someone can't simply be secretly arrested and locked away by the police and not given a chance to appear in court before a judge for the possibility of bail, for the possibility of contacting an attorney, for the possibility of having due process. So habeas corpus is also part of our rights, but it's not in the Bill of Rights. That's in the Constitution itself.